I'm Dave Summers, Executive Director of the Omaha Bar Association, and welcome to the 4th annual Bench Bar Briefing. Sorry, I should know the name of my own event. We started this event 5 years ago, and we missed one during the pandemic, but this is for just an annual tips and tricks from the judges for the practicing bar. And we've collected all the notes from the years, and we're going to keep on collecting notes so that every single member of the bar can get access to that and try to practice better in their courts. If you have any questions, please wait until the end of each judge's section, and we will have a break in the middle for some cookies and water. And I am going to stop talking, and I'm going to turn it over to Judge Bazis. Well, you've been on the panel before, I believe, right? You haven't? Okay. So you haven't seen this great microphone system that I have going here. We're going to do karaoke afterwards. So that we can have all the mics in one spot. There you go.
Okay. Thank you. All right. For those that don't know me, I'm Judge Bazis. I'm a federal magistrate judge. I've been a magistrate judge for 5.5 years now. Prior to that, I was a county court judge for almost 10 years, and then I practiced in Omaha, obviously, prior to that. So I'm here to update you about the federal court. We do have some updates. I'm glad to share with everyone that we are current as far as our trials are concerned, meaning civil and criminal trials are on track. We are no longer backlogged from COVID. So we are pretty happy about that, because the federal courts throughout the country, that is not the case, and it's concerning and a mess, to say the least. But fortunately here, we are up to date. As a matter of fact, there is a civil trial going on right now over at the federal courthouse. But along those lines, we do have a couple of general orders, and I do encourage everyone to look at those on our website. That kind of gives updates, particularly for the coronavirus and kind of what's going on with the courthouse, as well as we are allowed to do remote hearings in criminal matters, and I'm trying to look, I don't know how many criminal lawyers we have in here that do any of that, but we can do remote hearings criminally, and the chief judge has to sign a general order indicating that he wants to continue that outside of what is provided for by statute. It's pretty limited as to what we can do by statute, but due to the coronavirus, the Judicial Council in Washington, D.C. expanded our authority to do that, but it does take a general order every 90 days to allow that to continue. So our current general order goes to November 29th. I do expect that Judge Rossiter will continue that as long as we can. For a couple of reasons. I can tell you in Omaha, we are back in person on all criminal matters unless requested by the council to do it remotely. However, in Lincoln, they are mainly remote because our holding facilities are so far away from Lincoln, some 2-3 hours away. So being able to do it remotely is pretty efficient. So that is one of the big differences right now between Omaha and Lincoln. But I do remind everybody, if you want to do it remotely, you just need to ask, and we're happy to accommodate that. And then the other general order that we have has to do with masking, and we are following the CDC guidelines. So if community transmission is high, then masks will be required in the common areas of the courthouse. It is up to each individual judge whether masks are required in the courtroom. If they're not required in the common areas, I can tell you none of the judges right now, be it district or magistrate judges, are requiring masks. However, if they are required in the common areas, then there are some that will follow that through in their courtrooms, others don't. So you can always call the courtroom deputy and they can tell you what the procedure is for that week. And that decision is made every Monday, just so you know. So we make that decision on Monday, and that carries through for that full week. So since high, medium, and low, we've only had to do that, I think, one time. Prior to that, we had a consistent mask mandate at our courthouse, but that's where we are now. I just want to remind everybody, in August, we look at amending our court rules, both civil and criminal. And those went out for comment, and there will be some amendments. A lot of it is just cleanup, but there will be some amendments to the summary judgment procedures. So I do encourage you, those will be posted on our website if they're approved by the Judicial Council, which will actually happen next Friday. And so if that does get approved, those will be on our website, and I encourage you to look at those. It has to do mainly with the statement of facts and how that will occur, and procedurally how to do that. And then we had rules that were passed last time looking on the notes. I think Judge Roster and Judge Nelson talked about that a little bit, but I will highlight a couple of issues. It is required, it's always been required, that if you're going to submit exhibits that you need to put an exhibit sticker on there. You now have to put the case number as well as obviously the exhibit number, which is, I can tell you, the courtroom deputies really like that rule change. It's been very helpful to them, and it quickens up the process of what they have to do. So that is number one. Number two, probably the biggest changes is if you have an exhibit that cannot be filed, such as an audio or video file, that does need to be, a copy of that needs to be dropped off to the clerk's office. You can't just send a link to a cloud storage service or Dropbox or something like that. We need the physical audio and video files. So if it goes on appeal, then that can follow it. So just a reminder about that. And then on the criminal side, do we have any criminal lawyers here that do any criminal work? Because otherwise. Okay, so good point. One of the probably biggest changes for the criminal side is there was an amendment prior to sentencing. There was a sentencing recommendation that was provided to all counsel, defense, prosecutor, obviously the judge. That now, whether that is distributed to the attorneys is up to the individual judge. And so that is a substantial rule change. I can tell you that's the way it is around the country, but we had been more transparent, I would say, in Omaha, but that is one of the rule changes, that it is up to the district judge whether that sentencing recommendation goes to the government and the defense attorney. I would also remind everybody that based on conversations or meetings that we had with the civil bar and criminal bar, which we did every year for the last couple of years prior to the pandemic, we will restart that up again this April or May. But out of those meetings, we did, the magistrate judges developed civil case management practices. So what we were doing in Omaha was the same as what was happening in Lincoln. Probably the biggest complaint we heard is Lincoln's doing it differently than Omaha, and Omaha's doing it differently from Lincoln, so we have to do it two different ways, and we don't like that. So the magistrate judges got together, and we have one system, and that document will explain the case from the beginning to the end and what you need to do. It has a lot of great guidance, so I encourage everybody to look at that. The other thing that we did develop was the Rule 26 report that you have to file. We have a calculator. So for example, if you want your trial by a certain period, if you put your trial date in, it will pre-fill all your other dates as to when that needs to occur. It's a pretty handy tool, but I don't think people know about it or use it all that often. So I encourage you to look at it, particularly if you have a timeline that you want to have your case done by. The other thing I would note is that the district judges are looking at changing the requirements of what they are requiring kind of from the pretrial that the magistrate judge handles and the trial date. So for example, motion in limines, one judge is now requiring those 28 days in advance. They're requiring jury instructions 21 days in advance. Previously in this district, it's been 7 days prior to trial. And so there is one judge that's doing that. All the judges are looking at that, trying to see if they can get a common time frame for everyone, but I just caution everybody. Right now you'll get an order from that particular judge giving the guidelines. Just make sure you read it and comply, because if you don't, you're not going to be able to do it. So just keep that in mind. If you have any questions, we can certainly answer those during the pretrial that the magistrate judge has. But those are some changes, and so those will be posted on the website as well, and we'll talk about that probably in April or May when we have those other meetings. The other thing I would say is I encourage everybody, if procedurally you're unsure how to do something, or you think you need to have a conference with the court, or you need the court's assistance to resolve an issue, don't hesitate to contact the magistrate judge's chambers. We're here to help. We want to do whatever we can to assist you in getting your case progressed. So don't hesitate to call. If we can't answer it, we'll tell you that. Otherwise, we're pretty helpful, and our staff is pretty helpful in guiding you into what you need to do. So I do encourage you to do that. Along those lines, just as a reminder, you can't file a motion to compel without first contacting the court, and we're going to have a phone conference about that. And our goal and our hope is that we can resolve it on the conference, and you do not have to do formal motion and briefing practice, which will delay your case until it's ruled upon. So that is the goal. If we rule in that conference, you can appeal it if you don't like our decision, just as if I had done a written order. You still have all the rights that you would have if you filed a motion and we ruled on it that way. I just want to remind everybody of that. But you do need to do that. But having said that, and this kind of goes along with the helpful hints or tips that I'm supposed to talk about. Our requirement is you need to meet and confer before you contact the court, number one. And a true meet and confer is that you talk on the phone. Yes, you can email, but before you contact the court, you need to talk on the phone. That is the requirement of all the magistrate judges, and I'm going to tell you why. It is our firm belief that things get accomplished more so by talking on the phone than just through emails. And I think, and I encourage everybody to listen to the other side, try to understand where they're coming from, and see if there's a compromise there. I cannot tell you how many times I have gotten on a conference call and they said, yeah, we met and conferred, and yes, we talked on the phone, and then we talk, and one side will say, well, I didn't understand that's what you were saying, or I didn't understand that's what you meant. So I just encourage everybody to try to listen to what the other person is saying. And really, a lot of times when that happens, sometimes we'll get the call and we'll say, we don't need the conference, we worked it out. Or because if you haven't done it, we'll tell you you need to meet and confer. That means you need to talk on the phone. And then usually it does get worked out. The other thing I would say is be careful what you say in emails, because ideally one side will probably give them to the judge prior to the discovery conference. So we all know what you've all said to each other, and sometimes it's not very nice, which doesn't really facilitate trying to come to a compromise, right? So just remember that. If you don't want the judge to see it, you probably shouldn't say it in an email, because I can't tell you, I end up with emails almost in every single discovery conference of what was said to each other. So just keep that in mind. So I think that does the updates. The other thing, well, big picture, one of the questions that was asked was big picture advice that you have received. So I'm going to talk about that, which probably the best advice that I ever got actually was from a law professor, which people have heard me say this before, I think, which is to return your phone calls, which now are emails and text messages. But the best advice I can give is to return your phone calls. And I did that as a practitioner, and sometimes it was very late at night, but I did it, which I think was very helpful with clients and maintaining that confidence of the client. But having said that, I also will say I think it's very important that as lawyers that you return phone calls or emails to the other lawyers. Because again, One of the other tips I have is don't run to the court too soon for help if you haven't truly met and conferred and talked about the issues. Now, obviously, there are times where you've emailed a lawyer or called a lawyer and they're not responding to you. Do you need to wait a month before you come to the court? Absolutely not. But on the receiving end of that, the lawyer who may not be responding, if you can't respond, for example, if you're in trial, I would always tell my clients, if I'm in trial, I'm not going to respond to you till my trial is over with. That's just, if it's an emergency, tell my staff to see what we can do, but I'm not going to have time. Well, if you're in trial, have your staff or have an outgoing message saying that you're not going to be able to respond, because I can't tell you how many times someone's come to me for a discovery dispute because they won't respond, they haven't answered the discovery, and we need to keep this case moving. And so then I ask for the position statements, and what I get back is, well, I was in trial, so I couldn't respond. Or I had a death in the family, and I would, all reasonable things of not responding. So it's my position, and generally the position of the magistrate judges, that somebody has at least 48 hours to respond or 72 hours to respond. I personally like 24, but I realize that may not be realistic. So, so keep that in mind before you contact the court, but also if you're not going to be able to respond, that communication needs to go back to the other side so they know. So that's one of my, I guess, suggestions or tips. And then the last thing I'm supposed to talk about is life satisfaction. So kind of work-life balance, and how do you do that? I learned, well, when I had my law practice, it was not realistic for me to go on a vacation for like a week or two. I just couldn't do it. So what I did is I adjusted, and I'd take a couple weeks, a couple days here or a 3-day weekend there. Fortunately, my husband and I like to see concerts, and so we'll go out of town and see a concert for a weekend and make it, 3 days. So I do think it's important that you take the time that you need to kind of re-energize, and you just need to make that happen however that's going to be, if it's 3 days, or if you like to take a week, you just need to accommodate for that. But I also think it's important each day to try to take time for yourself, whatever that may be. If it's drinking coffee and watching a soap opera or watching Housewives for 10 minutes, whatever it may be, whatever your guilty pleasure is, to do that and just get some time for yourself if you can do it. And I know it's really difficult and really hard, but sometimes you can do it in the morning before anybody else gets up. But whatever you need to do to try to do that, at least that's been successful for me. Everybody works really hard as a lawyer. It seems like the work never ends. It's that way as a judge as well, believe me. There's always stuff to do, but you got to take time for yourself in order to be the best that you can be in either doing your job or presiding as a judge over a case. So, all right, I think that's all I have and all the updates. So if you have any questions. Yes.
So on the informal phone call,
Mm-hmm.
before the vote, I want to make sure I have this right. So it's a conference call with both attorneys, both sides, and you on the phone, set before they said anything to you. Not even like they're going to be heads up, we're going to have a phone call, you set a phone call, and the rest of the motion can go but nothing else is said.
So, great question. So we do, and this has kind of evolved over time. So we require a 2-page statement. That's all we want of what your position is and what the issue is. So we know going in and can be prepared to try to resolve it. It is tape recorded. So if you want to appeal it, the district judge will have what it is and what the ruling is. Most effort is made in the text order entry that's done, if we can, specifying each decision we made, but sometimes it's either too complicated or there's too many, so we may say as ordered in the telephone conference. But all of them are recorded. So I will say this, if you're not seeing that recording uploaded and let's say you want to listen to it again and you're not seeing that it's uploaded, doesn't mean it wasn't recorded. What that means is I didn't call the judicial assistant to upload it or email her because I do the entry and then I have to email her to upload it. So it just means I forgot to send that email and it's there so we can upload it. So it's a perfect example. Call Chambers and say this was recorded, I'm not seeing it, and it'll be uploaded within 2 minutes. So now there are times though we'll get those statements and it may be too complicated or it's maybe not the correct form for us to do it over the phone, and we may say, just file your motion to compel. But I would say 98% of the time, we are resolving those on the phone so the case can keep moving. Because you have to remember, if you file the motion to compel, by the time that it's ripe, that's 21 days. And then it depending on what else we have going on, and we have a very heavy criminal docket here, so it could be another 60 days. So your case is kind of stalled for that 90-day period. So, and generally we're getting those phone calls in within a week or two from the time that you notify the court. So we're getting those in pretty quickly, trying to get those resolved. Any other questions? Yeah.
Are these settlement conferences mandatory?
Great question, and no, they are not. Now, and part of that is with 3 magistrate judges in the caseload we have, we couldn't do settlement conferences in every case. And I know that there's other jurisdictions that do, but you get about 2 hours, which none of the magistrate judges feel that that's enough time. So we do encourage settlement. We do encourage mediation or settlement conferences, and we will talk to you about that throughout the case because we do have status conferences and check-in calls with you. And so generally for settlement conferences, because we can't do them in every case, we generally get involved in kind of 3 scenarios. 1, the case was mediated, it wasn't successful, there's been further discovery, and they think that it may be beneficial to have a judge in there at that point, number 1. Number 2, sometimes the client needs to hear it from a court officer or a judge and not some random third party who is an attorney and very experienced, but for whatever reason, they think that will be more impactful for the client. And then sometimes in employment cases, there might just not be either the money for mediation or it just makes some sense to have the court do it. And sometimes it makes some sense to have the court do it, particularly if there's been a lot of motion practice that we've dealt with, that we know the case pretty well, that it makes some sense for us to do it. So all the magistrate judges are happy to talk to anybody about a settlement conference. We're happy to do those, but I will say we all want settlement fully explored, meaning that you have made offers and there are responses and where that stands, and that wherever you end up, that there is some hope that with the court's intervention that you can get to a settlement. What the courts don't really have the time to do is start from ground zero where nobody's talked about any money and kind of work through all of that you do in mediation, because we just don't have the time. We at most can give you a day, and particularly in Douglas County, based on the criminal docket, or in Omaha, it's a little hard to even get that day. But I will say the district judges are very happy when the case is settled, so anything we can do to do that, we will try to assist you in doing that. The other thing, which we are redoing our mediation plan, and you will see this, and I will remind people, if you have someone who just wants to go to mediation and you think that that's the appropriate form and don't have the funds to pay for it, the Criminal Practice Committee does have some funds for mediation, but there is a process that you have to go through to do that. And that is all in that mediation plan and the federal practice fund. So there is some ways to pay for that, even if your client may not have the funds to pay for it. And if you're just wondering about a settlement conference and you think, hey, this is a good time, but you're not having a status conference with the judge for 2 or 3 months, just call up and say, we want to talk about a settlement conference. We'll set a phone call and we can answer all your questions. And from that, you can decide whether that makes sense and it's a good thing to do now, or maybe you want to do it later. I will say this, I'm seeing more of a trend of not wanting to do mediation or settlement conferences until a ruling on summary judgment. Obviously, the problem with that is between summary judgment and your trial date, you may only have 2 weeks. So that probably is not the best time. I realize that may be the best time for your case, but I ask you to think about that because we'll talk about that at the setting of the pretrial and trial date, and whether it really makes sense because you won't have a lot of time. I'll just be honest with you. So, any other questions? All right, thank you.
Hello, my name's Stephanie Hansen. I'm a county court judge in Douglas County, and sometimes after you go after the federal court, it's like I feel like now we're going to talk about the Wild Wild West. So it's not quite as formal. County court, as everyone knows, is the highest volume court. We have a lot of cases. We run lean. We have few resources. So. Be patient in county court. Sometimes it takes a lot of patience to practice in county court. For Douglas County, staffing has been our biggest issue since COVID, kind of just like going to a restaurant or going other places. We're really struggling with staff as well, which means that of the 12 judges, we don't have 12 bailiffs. So it's a lot of sharing. It's having new people come on who have to learn a DOS-based system. So you take people who were born in the 90s and you teach them a 1980s program. So it actually takes a little time. So be patient with them and be kind to them as they're learning, and they're learning how to operate in this crazy, fast-paced county court. So the good news is we have gotten a few more bailiffs on board. They're going through the training process. Our clerk magistrate, whose name is Ron Murtaugh, created this really cool training program that is he basically took recordings from the court, so like how you do Liberty Recorder, so it makes a sample, and then is playing those in a fake justice environment. So it's that same environment that they'd be using in the courtroom, but it's a training environment. So it's like Husker County, and they listen real time to one of the real 12 judges on the bench, and they go through and they click and so they're learning. So it takes out some of that scariness for the first time that you're in court. So it's really been great. He's done a tremendous amount of work on that, and actually the judicial education branch, or the judicial branch education, is even certifying it so that they get hours for it, which is really cool. So that's some good news. Another kind of sneak peek of some good news that's coming is that we're going to be raising our court appointment fees. I think you'll continue to see that go up in county and district court, which is well needed. The NSBA did this survey of court appointed counsel rates across the state, and it was embarrassing. It was bad. So I think so we'll be seeing that gradually ratchet up. So that's good news for everybody as well. So please, if you haven't signed up to be a guardian ad litem in county court, we'd love to have you. Let's see, court operations, some more good news. We are getting ready to hopefully reopen kind of as it had been before. Right now we're on a consolidated schedule where not all the trial courtrooms are open at the same time. We haven't been able to handle civil juries, but as the staffing has increased, we're able to get back to more normal operations. So we're shooting for November 1st, hopefully. That's kind of where we're at right now, hoping to open the courtrooms back. So the only thing at this point that wouldn't include would be the jail. The jail will still be via WebEx, and that's just a staffing issue. So we're hoping to be able to have court live back in the jail courtroom, hopefully after the first of the year. So those of you who do criminal cases and have to do WebEx at the jail for bond settings know it can be really challenging. And again, another test of patience. I should be the most patient person on the planet by the time I get to retire. Okay, so some courtesies to keep in mind when you're operating in the Wild Wild West in county court. It's very helpful to have proposed orders ready to give to the judge at the time of your hearing. We really appreciate those. There's a lot of court-approved forms out there that are fillable online, and it's super helpful if you bring those in, as opposed to having, again, some of our bailiffs who may be kind of new, or it's like flipping from one screen to another. It's helpful to have them. We like that. If you can have your exhibit stickered, we don't have a rule, but it's a nice courtesy. We like it. I mean, at least put the sticker on it, because if you don't, I will. I have to do it. So then that means that my attention's divided during that time. So again, it's a really great courtesy if you can do that, please. If you're running late, please let someone know. A lot of times we sit around waiting for people to, are they going to show? I don't know. Have you seen them? No. And then we end up using the deputies as some sort of like, old school telephone system. Like, have you seen over here in courtroom 26? And so then that kind of goes around back and forth. So if you're running late, just let someone know. A lot of times the prosecutor, the defense attorney will give a message, or a bailiff will give a message if you're running late. We're happy to accommodate as long as we know you're coming. County court has no law clerks. So if there's something that you can do to help you decide your case, do it. So if that means is something as simple as bring a copy of the law, bring a copy of a case that you think is on point, do a real simple bench brief. Those are really helpful things, especially if there's something that is contested. And especially you see that in civil cases, you see that in probate cases. If anything you can do to help us, help you, we appreciate that. Let's see. Trying to think if there's any other court operation stuff. I don't think so. E-filing and modernization. So I know that Dave Summers worked with Ron Murtar, court administrator, to do a video regarding switching things to the PDF-A format. So my understanding is if you're going to e-file, it has to be in this PDF-A format. So if there's any hyperlinks, which includes like your email, if that hyperlink so that they can send you an email from your little thing, that'll knock it out of the system. If you're using DocuSign, it knocks it out of the system. So pro tip, the easiest way to do this, instead of saving as a PDF, do print to PDF. And if you do print to PDF, it takes away all that background noise. So it takes out the hyperlinks, it takes out, even if you're using DocuSign. So just remember, print to PDF, that's the easiest way to do it. Then do it through e-filing and it won't get rejected. Because every time even if it's not rejected, it creates a lot more staff work. Because then if the 20 to 40 ones that come through that don't convert straight into PD or into e-filing, that means the staff has to print it out and split the atom, getting it back up in there. So that's another helpful thing. Okay, so advice. We all love advice. So the best advice that I got was from my husband's uncle, who is an old guy at Fraser Stryker. And when I graduated law school, he said that the most important people at the courthouse are the staff. If you're nice to the staff, that can make or break you as an attorney. So if it's, Douglas County 429, and you have something that you really need to get filed and you need to have that file stamp, if you're the person who takes the time to say, "Hi, Barb, how you doing today?" Or compliment, just be a nice person to them, they're going to make sure that you get that order in, you get that thing file stamped, and that'll make a difference. If you're a jerk, the window's going to come down like, "We closed." So the most important thing you can do is they really can make or break you. Be the person who's the most prepared every time. As a lawyer, we come in and you want to do a good job. You want to be a good advocate. It's not always who's the smartest person in there. It's the person who's most prepared. It's the person who's thought about their case, not only from their side, but from the other side. So to Judge Bazis' point, have you thought about where the other side's coming from? Do you know what their issues are? And are you prepared to deal with their issues? It's not just about building just your case, but building your case also means understanding the strengths and deficiencies of the other guy's case. Your behavior. Behave through your actions, your words, and your appearances. The way that you want the world to see you, the way that you want the world to see our profession. Dress appropriately, speak appropriately. Be that kind of person that we're a noble profession. Be noble. Which also is a good reminder of those mics are hot all the time. We're running a digital recorder and they are very sensitive. And even if you're not at counsel table, they're all over in the courtrooms, and so they pick up, and it'll be like, Mike Six got Jane Wagner saying something, whatever, and you pick it up. And so when we go back, and if we have to listen to something, sometimes you hear a little tidbit about yourself, and you're like, I did not know everyone liked those shoes. That's good to know. And sometimes it's something not so nice. So just remember all those things. Get involved. A really great way of increasing your confidence, your practice, even your love for the profession is to get involved in things like the OBA, INSA Court, the NSBA. There's lots of different professional development things, and you get to know people as people, and it's really nice because we don't always practice in the same groups or the same fields, so to speak. So it's nice to get to know people on that one-on-one. And it also is really helpful, even if you're not looking for a career move, you might have a case where it's some obscure thing that you remember that somebody that you met at INSA Court happens to be an expert in this thing, and you can pick them up and you can call them and call them by their first name, and they might actually take your call. So that's a great asset to have as well. Is there's we don't know everything. I thought when I went to law school, I was just going to learn all the laws from 1 to 1,000,000. And as we know, that's not how it works. So it is really nice to be able to pick up the phone and have someone help you through something that maybe you just need to understand better. Do something for yourself. And this kind of goes to that self-care. Do things for yourself. What is it that you like to do? Do you like to travel? Do you like to exercise? Do you like to cook, read, things like that? Make time for those things to take care of you. Don't be one-dimensional. Do things that are a little different. And again, we're all different in what it is we like to do in our free time, but don't forget to enjoy that free time so that you're more pleasant to be around every day. I think one of the other big things for my advice is to try not to take things really personally. And I'll tell you that, I tend to take things kind of personally sometimes. And it's hard, is that you have to I call it channeling my inner golden retriever, and just kind of finding that happy place and relaxing through something and realizing that somebody else's problem isn't necessarily mine and I didn't create it. I mean, if you create it, own it. But if you didn't create it, let it go and don't take things personally and don't let them weigh you down. All right, any county court questions or questions about all my great advice?
What are the increases in the rates for guardian ad litem?
I'm sorry?
What's the increased rate that you know of for guardian ad litem?
Well, like I said, it's kind of leaked information at this point, but I think it's going up to $85 in county court for guardian ad litem, and that it's going to continue to increase, but it has to, we're the government. You can't just you can't throw it all out there at once. We gotta tease you along. But the good news is it's a much needed increase. I think the last time the rates were increased, I was in high school. So, Tasha? Either way is fine. Yeah, either way. And you're doing mostly probate, so if you do the e-filing ones, they'll put those in the file for you, which is really helpful. And so when we go in, they'll be in there. Certain things, like if you really don't know how one thing or another might go, you might be prepared just to bring in a couple of different orders. You know how those kind of situations go. But yeah, I mean, e-filing is fine as well. But the proposed orders really do help a lot. Sure. But I've been told by some staff that they've been told they're not supposed to give them out. So we've been placing them on the tables, on council tables in all of the courtrooms, so criminal, civil, and probate. So, anytime you're in there, if you want to just sneak a sheet, I won't bust you on that. So no, but it is, again, it is helpful because it does get, and even if you don't stick the number on it because you don't know what it is, but it's like if most of it's filled out, it does save a lot of time, and it is helpful. So All right. Okay. Thank you.
All right, so I am Tricia Freeman. I'm on the county court bench in Sarpy County. So I've been there for 5 years, spent 24 years prior to that in the county attorney's office. Talk a little bit about Sarpy County. We're in the 2nd Judicial District. It includes Cass and Odo counties for the county court, just so that you kind of understand the demographic there. We have 3 judges who sit in Sarpy County and then 1 judge who covers both Cass and Odo counties. We've been down a judge since the end of April. Judge Wester retired at the end of April, and so we're actually very pleased that the interviews for the 3 candidates who are being considered for his replacement interviewed today. So fingers crossed, we're not too far away from actually being back up to full staff, which we're very much looking forward to. We are definitely busy as a court. I would definitely agree with Judge Hansen. Our caseload is high, our numbers are up. I just heard yesterday that we're up about 7% from where we were the same time last year, and the expectation is that we will be at pre-COVID numbers by the end of the year. So, and that covers all, types of cases, criminal, civil, probate. So definitely the numbers are up. There are 2 of us that, of course, been working our tails off, and then we've had a retired judge. Judge Brodbeck has been coming in 3 days a week to help us with criminal and civil, so we've been grateful for him, but we definitely will look forward to being at full staff. In this transition, a number of cases have been kind of shared and in some instances reassigned. Maybe that will level out a little bit and things will move around again. Maybe they'll stay where they're at. So I'm just kind of putting everybody on notice that we adjusted with being just the 2 of us who were there, full time all the time, and just tried to adjust so that we could get the cases heard. We are up to date. We've tried to maintain, doing trials and doing contested, probate issues. Maybe if we're behind on anything, we're maybe a little behind on doing civil trials, just because we just haven't had the time to set that time aside. But I would think that for the most part, we've tried to maintain, kind of some consistency in keeping things going. Let's see. I brought with me a copy of our calendar. We actually keep a weekly calendar of what's happening at what times in county court. Primarily because if you want to know when do we do criminal arraignments, when do we do our probate show causes, when do we do, restitutions, the calendar is going to tell you when we do that, because we do it on a fairly consistent time every week. This calendar was last updated in May, so it is current to date. So just feel free to grab one of those. A couple of things that I want to highlight. Realize we may not have a lot of people that do criminal here, but maybe people that will listen, so I want to cover a couple of things. Bond reviews we do at 8 o'clock every day, and our bond hearings. Those are cases where the defendants don't have a bond set. So they've been arrested for a felony or on a capias, or that there hasn't been a scheduled bond set. So we're going to do those every day at 8 o'clock. If they've had a bond set or they want a bond review, we have 2 times set aside for that during the week. We do those at 1:30 on Mondays, and we do them at 9 o'clock on Thursdays. Again, those are people sitting in the Sarpy County Jail that need hearings, that are bond reviews or already have a bond set, and they want to enter a plea of some kind, and there's been an agreed sentence. We tried to set those times aside so that there's only one, we can only have one courtroom connected to the jail at a time. And there are as many as 7 courtrooms that could need to do hearings with the jail at any given time. And so we tried to parse out times when we could do our hearings and not interfere with what everybody else was doing. And so that's why those times have been kind of established. For those of you that don't know, if you haven't been down in Sarpy County in a while, we have a new jail that is near completion. It will be final punch list at the beginning of January of 23. So we're on the cusp of that facility being open. I anticipate it will take them 2 to 3 months to have everybody trained before they start transitioning inmates to the new facility. So there's still a little bit of a transition time there, but that's going to change, I think, a lot of what we're doing when it comes to those video hearings, because there's going to be 9 different ways that video hearings can occur. So we're certainly looking forward to that, but we're not there yet. All of our courtrooms are outfitted with video equipment so that we can do video hearings. Now, the fact that it's outfitted with equipment still does not solve the mystery of why it works one day and doesn't work the next. We haven't been able to solve that with our many meetings with IS. So just understand that we authorize video hearings if they're requested. But sometimes, due to circumstances beyond our control, we can't facilitate it because we just simply can't get the equipment to work. That being said, primary means of conducting hearings in Sarpy County are personal appearance, not video. Video is the second option. We will entertain it, we will authorize it when it's conducive and when we think that we can facilitate it. So just be aware of that. Just kind of as an aside, the Court Administrator's Office has entered into a contract to provide statewide audiovisual upgrades in all the trial courts across the state. I think that they initially thought they would have all of it done by the end of the year. That's not going to happen. In fact, they're probably middle of next year for a number of different reasons, but perhaps that will bring some needed consistency among the different trial courts as they continue with that project. Let's see. I think that's general updates about courtroom rules and procedures. Do's and don'ts. Talked a little bit about video appearances. In county court especially, and please understand, I'm talking about county court. I can talk about anybody else's court from where they ask me to. Don't send emails or text messages to the judges. We won't respond to them. I don't even care if you send a notice to the other lawyer so that it's not ex parte because I included the other lawyer. We don't do business that way. We're not going to communicate that way, so just don't bother. If you need to get in touch with us, the best way to do that is to call our stenographer. I feel very fortunate. All of us judges have a stenographer that is assigned specifically to us. And so if you're wondering who that is, if you'll call the clerk's office and just ask for Judge Freeman's stenographer, you're going to get Stephanie, except she's going to go on maternity leave and then it'll be Jill. But we do have specific people who assist us in that regard, so please communicate in that manner. If you file a motion to continue and it's not granted, assume you have to come to court. And don't file it 10 minutes before court and then call and ask if the judge has seen it. I can guarantee you we haven't. It just doesn't process that way. Don't file it at 10:30 the night before for a 9 o'clock hearing the next day and think, well, the judge surely will have seen it and will do something with it because I filed it the day before. We're still likely not to have seen it. Maybe I like e-filing, maybe I don't. That's for another day. But what I don't like is that the rule says that your filings are deemed filed the day they're filed, whether they're filed during business hours or not. I feel that creates an unreasonable expectation about how quickly we're going to respond to that information. The fact that you e-filed it just means it's got a date and file stamp for that day and time. That's it. It doesn't mean that staff have touched it. It doesn't mean that it's gone through our process, and it doesn't mean that it's made it to a judge's desk. So especially with regard to motions to continue, it's interesting to me, especially on a holiday weekend. Get 25 motions to continue that were filed sometime over for Tuesday at 9 o'clock, and the expectation that we've seen them, that we've responded to them, that they don't have to come to court. Just know that that's not how we perceive it. If we haven't responded to it, then we expect you're going to be there. So I know there's lots of discussion with regard to appeals. And specifically, our stenographers asked that we would talk about this. The e-filing rules for appeals cover or address appeals from county court to district court as well. And I think that there's been some confusion, at least in Sarpy County, that's how they treat it. That's been the message that they've gotten from the court administrator's office from any training that they've done, which means that the record has to be electronic. If there's been a hearing and those documents have come in, or there's been physical evidence that's come in, tangible, it now has to be converted and treated as an electronic, evidence. And the person responsible for doing that is the party that offered it. And I think that you guys can read the rules, you know what they say, but that does apply for the appeals going from county court to district court. So please just be aware of that. Probably the one area that perhaps causes us the great consternation is adoptions. Adoptions is one of those areas where you shouldn't dabble. You got to be aware of it's very, very statute driven. The adoption laws changed, and there are some key differences in the laws on how you plead it, the documents that have to be provided, how they're provided, and what that looks like. Please be aware of that. Again, that's one of those things that it takes us a lot of time to go through filings on adoption cases. So please be aware that the law has changed and govern yourselves accordingly. Let's see. I think that covers everything that I had. I did send out a note to my benchmates in Sarpy County, including the district court, just to say, hey, I'm going. Is there any message you would like me to take to the meeting? I did get a response from Judge Martinez, who is one of our district court judges in Sarpy County. So I wanted to share some of her thoughts that she asked for me to pass along. She did want me to communicate specifically that it's just for her court, that all of the courts have a little bit different process, and so don't take this as anything other than the process for her court. Encouraged lawyers to make sure you read the local rules, because every court, again, differs a little bit. If you submit a pretrial letter prior to your pretrial conference, your hearing's likely to be canceled in her court. So there's some incentive there that if you've got something happening, if you've got a resolution, if you've got something to update, you can do that in advance, and that hearing will likely be canceled. Exhibits that are being submitted electronically should be submitted to the court reporter at least 48 hours in advance. They'll be marked and filled into the witness list. Providing them the night before or the day of trial doesn't provide the court reporter with enough time to get organized and be ready, and it will likely delay the start of the trial. And then communicating with opposing counsel as early as possible, keep the court informed of scheduling. And the benefit there is that by doing that, it frees up the time on the calendar so that additional items can be put in place, and then it doesn't stretch out the time between for trials and pretrial hearings, because other things are still scheduled on the docket, taking up some length of time when they could be removed and other things scheduled in their place. So please don't answer me any questions about any of that. I've given you specifically the text of what she gave me so that, okay, well, then good. Then I've covered it. All right, the final thing. So there was a question, big picture advice for law practice and life satisfaction. And I think that probably the thing that comes to mind, and I think it maybe even touches on a little bit of what Judge Bazis and what Judge Hansen says. Email, text messages, tweets, Instagram, Snapchat, none of those replace personal contact, human to human. And I think that's true in practice, and I think it's true in your personal life. I just at least I know in my own, in my own life, we were created as relational beings. We're meant to be in relationship with other people. And in our practice, it's with lawyers and clients and judges and witnesses and other people who are involved in the process. It's court staff and all of those folks. And having that one-on-one contact is, I think, essential to maintaining some sense of connectedness. You miss, well, I didn't mean it that way in an email or a text message, when you can say it and they can see your eyes and they can hear the voice inflection and know that, okay, yeah, I get that. I loved what Judge Bazis said about that if you're going to have a meet and confer, that it has to include a phone call, because you miss so much in translation when you don't. So I think that COVID was really damaging for that personal human-to-human contact. And as much as we had to be 6 feet apart, that we couldn't be together in the same place, that we got really used to doing things via video and via Zoom, and we wore masks, and so you couldn't see people's faces. And I think all of those things really did interfere with that human-to-human contact, which has a direct, I think, correlation on just your overall joy or happiness, both in your professional life as well as in your personal life. And so put down the phone, have a conversation. Instead of sending an email, pick up the phone and make a phone call. Instead of sending, an email to your partner, that's 2 doors down, get up out of your desk, it'll add steps to your watch or to whatever you're doing, to maintain that, and just go down and have a conversation, and talk to people. I think that overall, I think that would be the one piece of advice that I think covers so many situations. And I think the same is true in our personal life. So that would be probably the thing that, perhaps touches, I think, both of those things, and from a big picture perspective may have a tremendous impact on your overall perception and the joy you have in your life. I think that included everything that I had. Questions? Anything else that maybe I didn't cover or you have questions about?
Judge, do you prefer to have proposed orders as well, or do you prefer to do the order yourself?
Oh no, I don't. I do very few orders myself. Anybody who's practiced in front of me will know that I will say you can submit an order on that, and you can submit them via e-filing, like Judge Hansen suggested, or you can bring them with you. Either way is fine. We don't have, and they will print them for us. Sometimes if I see, things in an order that I want to change, I'll ask, or my stenographer will call and say, hey, will you submit that in a Word document so that I can make changes to it if I feel like there are changes that need to be made to it. But happy to have the proposed orders. I liked what Judge Hansen said as well, that, help us help you. Submit the case law, submit the orders. Sometimes that's what I'll ask for in place of a brief. It's like, I'm not asking you for a brief. I want you to submit me a proposed order. What do you think this would look like if I ruled in your favor? And I think that that's certainly helpful. So, yes, very much helpful.
Here. So I asked Judge Engleman if he wanted to go first or second today because we have 2 district court judges, and he said, I'm going to defer to Judge Stratman. She can go first. It's her right to go first. And then Judge Stratman pulls the reverse Uno card and he's like, no, I'm going to have him go first, and then say everything he said was wrong. So we have a very fun end of the CLE here. So here we go.
Since he set it up, I am going to say it. I'm like her mule. I'm just going to plow through everything, and then she's going to go, oh, yeah, what he said. That's great. Like I said, I'm Todd Engleman. I'm a district court judge in Douglas County. Going through some updates. As some of you have seen, there are 6 new judges that have joined the bench in the last year and a half. So this is just kind of a side note, please be patient. Some of them are coming up to speed, getting new staff, trying to find courtrooms to put them in, so be patient. Some other brief updates that we've talked about. I wasn't really going to say this, but then I got joking about it. There are signs on all of our doors when you come in our courtroom that say you can't use your cell phone. The judges are going to start paying a lot more attention to that. And so if you get slapped for playing on your cell phone, you can expect it because it's coming. And like in my courtroom, in Shelly's courtroom, Judge Wheelock's courtroom, we have cameras everywhere. And during trials, it's not beneath my bailiff to send me a message that an attorney's on their cell phone. So it just happened last week. She just sent it to me twice during trial that a certain attorney that I can't see because I have a big monitor right here was on his cell phone, and as soon as I peek around, puts it away. 5 minutes later, he's on his phone again. You look over, puts it away. So first, we've talked about it as a bench. Personally, I think it's really disrespectful, not even just to the bench. It's really disrespectful to the person that's paying you $200, $300, $400 an hour to be in court arguing for them, and they look over and see you checking your email and text and doing that stuff. It's just very bad. It's a bad look for attorneys. Next, dealing with updates. I am not a paper guy, so I love the electronic rules with electronic exhibits. I don't want paper copies. I mean, I have trials. Mr. Vipond did a great job, his co-counsel, but I had a jury trial week long where there was like 10 binders of exhibits, and going through those and just taking them up to the witnesses and having them thumb through them. Mr. Vipond's jury trial was excellent. Everything was electronic. They talked about an exhibit, shot it up on the TV screen, no paper around, the jurors can see it, the witnesses can see it. It was so quick. My courtroom, Judge Stratman's courtroom, Judge Wheelock's courtroom, we have all the up-to-date electronics. Sorry, everyone else. I don't know how it happened, we just do. But like in my courtroom, we have a dongle that you plug into your laptop, you hit it, your stuff gets cast up on all my TVs. It's that simple. So you don't have to be walking around with tons of paper and exhibits. And I don't want it up on my bench because I don't want all of that stuff cluttering. So almost all of my trial orders that go out now, and I think Judge Stratman's too, say we want electronic exhibits, send them to us. I can put them on my computer. I've got them right there on the bench. I don't need tons of paper. And it's, so as an update to that, just as a practical matter, if you're going to be appealing cases, like the previous judges said, they have to be electronic. So getting attorneys into the practice now of just getting all of your exhibits electronic from the get-go is going to save you a lot of time. I mean, in private practice, when we had clients come in to our office, the first thing we did is took all of their stuff, scanned it all in, and gave it all back to them. Then anything we have is already electronically stored. We don't have to mess around with keeping all this paper. So it's coming. I see it getting more and more like the federal courts every day. Praying. It's just a lot more efficient, but it takes a while to get to that point. The other update I have is a pilot project that I've started. I was doing it, putting it together with some of the members of my firm before I got on the bench, and now Greg and Megan Spomer have taken it over. I think they presented to the family law bar this summer as to what's going to happen. About half of the district court bench I've bullied into, they're going to start doing it too. But I'm going to start doing it November 1st as kind of the pilot project, and once we start getting it running smoothly, at least half of the bench is going to start joining on. And what it is dealing exclusively with family law and requiring settlement facilitation on property. Because one of my biggest frustrations as an attorney was I could never get a hearing date with the court, because you try to get a hearing date and it's 3 months out, and I'm like, God, what are these people doing? They gotta just, you can't tell me I can't get a hearing date. Now that I'm on the bench, I see exactly why it is. When you have 2 weeks of jury trials and then you have 2 weeks non-jury trials, I'm on the bench all day those 2 weeks that are non-jury. And when you have, I've had entire weeks set aside for domestic trials, 5 domestic trials, 1 every day. And the Friday before or the day of, every one of them settles out, and I've got nothing to do because we can't reset stuff within a day or 2 days. And so there's so much court time being lost on setting things for trial when almost all parties know it's going to settle. And it's tying up our dockets tremendously. So you're going to start seeing new orders coming out that set right from the get-go timelines going. And they're basically from the time the other party gets served, you've got 60 days to do the parenting classes, get mediation going. 60 days, the party who filed is going to have to do a property statement listing out all the property, whether they think it's marital or not, what the value is. They got to get it to the other side's got to do it too. There's going to be deadlines for getting the parenting mediation done. You're going to get a pretrial date set that's going to be 4 to 6 months down the road, so it's not like I'm going to try and cram everything in right away. But there's going to be a pretrial date, and by the time you come in for that pretrial, you've had to have done mediation on the parenting plan. You've had to have done a settlement conference so that when you come into the pretrial, these are the 1, 2, 4 issues we have to try, Judge. We can't get them settled, great. You get 2 hours or 4 hours instead of 2 days. So, and you're not getting a trial date until that pretrial. So, and I'm not gonna give you a trial date if you haven't done settlement facilitation and everything else. Part of that comes from, in private practice, I was a mediator and I mediated a lot of divorces. And I can state from experience, most people don't want to go to court. They want to settle. And whether it's one party's being difficult or one attorney's being difficult or something, we're gonna try and make things a little more efficient and start forcing people to sit down. And even the judges who aren't going to go to the extent that myself and some of my other younger judges are going to be doing, they've even said, we're going to start ordering settlement facilitation too. It's not going to be the big order that I send out, but you're going to start seeing some of the older judges even start requiring people to go to mediation on property, because it's just tying up so much of our docket. I've had a trial where I started it and it was literally about 2 credit cards and a car. And about 2.5 hours into this, I'm like, what are we doing here? We're gonna take a break. You guys are gonna go out in the hallway and you're gonna get this done. Where if they would have sat down with a third party, that would have been done in literally 15 minutes. So expect that to come. So that was my frustration as a private attorney and as a judge, because I hate not having things to do. I hate sitting around just twiddling my thumbs when I know, as being a private attorney 2 years ago, I know you guys are sitting out there wanting hearings, wanting to get into court, and the judges are telling you, we don't have any time. So we're going to try and fix that. Trying to think of anything else. Another thing, someone else said with the bailiffs and clerks, being nice to the clerks. I think most of you know who run most of our courtrooms. It's not us, it's our bailiffs. So if you're mean to my bailiff, I find out about it, but good luck getting a hearing date. She may be small and she may be young, but she's got a memory like an elephant. She'll remember. So be nice to them. And you also have to remember, you're not the only person that's emailing them. One of the things I love about becoming a judge is when I was in private practice, I get 100, 150 emails a day, just like you guys do. Now I get like 5, and they're all from my bailiff she's telling me to do these 3 things. So, but she's now getting 100, 150 emails a day. So be patient with the bailiffs. They're doing the best they can. And there's a lot of new bailiffs. So be patient with them too, because they're learning on the job. Another thing, my courtroom's electronic too. My courtroom's hot all the time. So if you're in there carrying on a conversation, we can hear it. So keep that in mind when you're in the courtroom. Those microphones are on all the time. My cameras are typically on all the time. Trying to think of anything else on updates. Can't think of any. On the do's and don'ts. Coming from private practice just 2 years ago, one of the things I've noticed is, I'm sure, I guarantee I did it too. There's always the tendency to make a point and then make the 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 point and make the point, and you get it. If you see us up there like, I got it the first 5 times you asked them, move on. Just keep that in mind as your practice. Make your point really well the first time, concise, and it also carries more weight than if you make the point. And if you keep making it, it's almost like you start wondering, why do they keep doing this? Do they even not believe what they're saying? Why do they keep saying the same thing over and over again? Along that line, there's courtroom demeanor. Coming from family law, I was also a prosecutor. Family law attorneys have a tendency to be just, maybe say, passionate, sometimes emotional, sometimes beyond even that. Keep in mind, you make your point a lot better when you make it calmly, succinctly, and don't fall into the other side's trying to be sarcastic and trying to go back and forth with them. Because all that does is your point gets completely lost in the back and forth sarcasm comments. So if another attorney's being sarcastic, aloof, just let them. We notice, we know what's going on, and quite frankly, we don't care. We just want the information. That's all. But that's one thing I see with younger attorneys and some older attorneys, but some of the older ones you're never going to change. But some of the younger ones, if I'm more passionate and I'm more outgoing, he's going to listen to me more. Probably not. I'm going to be listening to you regardless, but just make your point. Trying to think. As younger attorneys at points, if you don't know, ask. Just ask. There's no embarrassment in asking. Like I said, my bailiff ran a law office for years, then she became my paralegal, then she's now my bailiff. She knows everything there is to know about family law. I've had tons of attorneys asking her questions. There's nothing wrong with asking questions. What's worse is when you go into the courtroom and you do something that then I'm looking at you like, huh? Okay. Along those lines, read the local rules. One of my great experiences is a very young attorney against a pro se person on a temp hearing, had all their affidavits lined up on the table and they were ready to go. And I'm sitting there looking at the guy who's just looking at the table like, I don't even know what's going on. And I'm like, did you send all those to the other side? No, but I'm ready to go. Okay, we're not gonna go. And they're like, but I'm ready. I've got all my exhibits, I'm ready to go, Judge. And this was like a 5-minute conversation. And finally it was like, all right, well, I'm gonna get up off the bench and leave and we'll get you a new date, because they just weren't getting it. And I didn't want to embarrass the attorney by saying, read the local rules. You have to turn that stuff over to that person 48 hours before the hearing. You haven't done it. You gotta do that so he can respond. So I just got up and got off the bench. And that person came back to my bailiff and was very upset. She told him, go read the local rules. It's right in there. So try not to embarrass them, but know those things because they are different in every jurisdiction. Some in Sarpy County, I think most of their temp hearings in district court, they do on the record in the courtroom. We don't. We do them all typically in our chambers with just the attorneys, unless they want it out there. In Washington County, I know Judge Sampson makes you mark the affidavits and offer them, which I don't think any other court does. And Judge Sampson, if you don't comply with the local rules, he will literally throw your affidavit in the trash. I won't you. Because he asked me if I got the other side's affidavits 24 hours before the hearing, and I said, no, it's right on the email. It says 10:43 last night. Drops it in the trash can, and we go on with the hearing. So just be careful with those things. Some work-life balance. I can tell you, the two people who took over for me when I left my firm, I guarantee their stress level is a lot worse than mine now. So I don't think they understood what my stress level was when I was there, but they're getting it now. One of my things that I did in private practice all the time, and I tell you, you should do it, when you go home at night, just go home. Don't answer emails, don't answer text messages. One, there's nothing you can do at 10 o'clock at night that's gonna change anything, other than stress yourself out and you're gonna stay up all night worrying about it. So when you go home, go home. I know some firms out there who require attorneys to have their cell phones on and respond to clients till like 9 o'clock at night. I can't imagine why that is. That just baffles me. You need to be able to just go home and spend time with your family, go do whatever you want without constantly thinking of them. Because I've had clients contact me on the weekends and I'm like, what do you want me to do? Drive to the judge's house and get an order? Well, can ya? No. What do you think? So that was in my younger days, and I did not give my cell phone out to anybody after that. It's a good thing as a young attorney, just set your expectations right from the get-go with your clients. I'm not going to answer your emails after 5 p.m. I'm not going to respond to stuff. First, there's nothing that can be done at that point in time that we can't handle the next day. If it's a true emergency, call 911, because there is no emergency other than something like that. But setting the expectations with your clients from the very beginning will save you a lot of heartache and a lot of stress. My wife commented to me after I'd been on the bench for 3 months that was the first time she had seen me sleep through till the morning in about 10 years. Because she said I was getting up at 3, 4 in the morning and go in the office and get on the computer and start working. And now that's other people's problem. But along those lines, that's pretty much what I have. The only thing I would really stress is we are going much more towards electronic everything. So the earlier you can get in the habit of doing everything electronic, the better off you're going to be. Because the Supreme Court, they set the rules. A lot of times, we may or may not have input, but they're moving forward with it. So be prepared. I think that's all I have. I left raising fees to her so she'd have something to talk about. Oh wait, do you have any questions? Nope. All right. Jeez. By the way, I got asked to do this last week, so come on.
I'm Shelly Stratman. I'm a district court judge along with Engleman, who is sitting next to me. I've been on the bench for about 10 years, and I was a prosecutor before that. And so I understand the growing pains that the newer judges are having because they most of them came from the criminal world and are now trying to learn the world of family law and civil law. A couple of things I just want to touch on really quick since Judge Engleman took up all my time, so I'm going to be really quick so we can stay close to 3:30 as possible. As far as cell phones in the courtroom, we are going to be a lot more cognizant of that, and I understand that we are in an electronic world and you have your whole life on your phone and you're going to have to check your phone when you're rescheduling something or something comes up. It's just the courtesy of saying, Judge, may I please get on my phone and check my schedule? Or I have an affidavit that, can I please get on my phone and text my secretary to send it over? Just to be courteous about it. It's not, we're not going to throw them away or anything like that, but just be aware that it is rude, it is disrespectful, and people notice it. I can tell you that I met Mal last week, and the doctor who was on trial was on his phone, and the jury commented on it when I went back to talk to him, and they said we thought it was really rude, and he was completely disconnected, and he clearly didn't care. And so people are aware of that. So that's with cell phones. Local rules. So we have revamped the local rules, and some of them were to get rid of stuff that nobody does anymore, but a lot of it was geared more toward trying to make things more efficient and keeping everybody on the same page. There's 18 of us now, and I appreciate that we all do things differently. But those local rules are down with the Supreme Court right now, so we're waiting for them to get approval. But probably the biggest one goes along with kind of what Judge Bazis was talking about, and that is a requirement to meet and confer. I can't tell you how irritating it is to get a motion to compel and the attorneys show up and they have stacks of interrogatories and discovery requests and they haven't even talked to each other. And so I sit down and I go, okay, get comfortable. Interrogatory number 1. And the attorneys looked at me like, wait, what? And I go, you guys talked about these? Well, we haven't had a chance to. What do you mean you haven't had a chance to? We're here at a motion to compel. You're saying that you can't agree to 25 of these 50 interrogatories. Why didn't you have a conversation? So that's been an ongoing issue, a lot of times more so in the civil arena, but so that's one of the changes that you're going to see. So not sure when the Supremes are going to get around to it, but be looking for those new local rules and make sure you read through them. That also being said, and knowing that some of my colleagues that have been around for a long time, you might be able to just call up and say, hey, that trial date's not going to work for us anymore, so we're going to continue it. And I know some of my colleagues were just like, well, okay. there's a statute that requires you to file a motion to continue that shall be supported by affidavits, 25/1148. And I required it in my courtroom, and the first 2 times that I required it, they were looking at me like, what are you talking about? I'm like, it's in this red book, and it's been there for a long time. And one of the things that, just so you know, in my courtroom, it's required. You can call up, and maybe it's something that after the conversation with my bailiff, I agree, but I'm still gonna make you put that motion on file with a supporting affidavit. And one of the most important things in that affidavit needs to be that your client knows you're asking for a continuance and they are in agreement to that. That is to protect you and it's to protect me. So that's that electronic exhibit. So I realized that the rule change was more specifically toward if things are appealed, then those exhibits must be submitted electronically. Because Judge Engleman and I and Judge Wheelock have the more updated technology, I've approached it with, we're gonna make everybody submit everything electronically up front, because that's gonna save you guys in the long run, because you may offer a bunch of exhibits and then things go sideways and you need to appeal, and then my court reporter is going to be saying, where are your electronic exhibits? Part of the discussions that we've had too is trying to eliminate, if there's a physical exhibit that is offered at trial and it goes back with the bailiff, then my bailiff or my court reporter does not have time. We are constantly doing things. She is constantly doing transcripts. She doesn't have time to scan hundreds of pages of your exhibits. And like the rule says, if you offered it, you're the one who has to have it electronically. And the problem that's come up is people say, well, what if it's offered, but now it's sitting in your court reporters, it's in evidence, and so we have to come and get it and scan it. What if somebody tries to change it out to something different? You know, there's a lot of people who are concerned that maybe something might be added or adjusted or whatever. So that's how we're going to do it in courtroom 315. Is everything's going to be submitted electronically up front. Phyllis is lovely. If you haven't met her, she's wonderful. You need to come in and meet her. She's one of the sweetest people you'll ever meet, and she is there to help you. So I have had, I won't use his name because he's getting mad because I tell the story all the time. He's been practicing in Omaha forever, and he came in on a motion for summary judgment, and I said, you got to do it electronically. And he looked at me like I was speaking foreign language, and I said, don't worry about it. Phyllis is going to walk you through it. And he did a fantastic job on his electronic exhibits for a motion for summary judgment. So it can be done, and Phyllis will walk you through it. And it really, in the long run, is going to be the way it's going to be. I really think the future is there's not going to be any paper, and obviously the federal system, Iowa, a lot of other jurisdictions have already figured that out. So, domestic cases, my bailiff wanted to make sure that the domestic attorneys, I don't know why this is, and maybe you guys can look into it, but if your clients go through the what about the children and they get their certificate, it does not automatically get sent to conciliation court. So you have to make sure that that is sent to conciliation court so they get credit for taking it and it's on the books. So I don't know why that is, but I just wanted to make sure that that was in there. Also, even if you have a very amicable situation and everything is agreed to and it's in the decree, and part of that agreement is that there's not going to be any child support, you still have to do a child support calculation. You still have to submit a worksheet 5 that says we're deviating from it for whatever reason. You have to have that in there. So there's a lot of attorneys who've been practicing family law for a long time. I'll get a decree with waiver of hearing, and there's no child support calculation. And my bailiff will call them and they'll say, well, we agreed to it. We agreed that there's not going to be any child support because dad's taking care of their car insurance or whatever. Yeah, you still have to submit it. There still has to be that calculation. Let's see, what else? Okay, get close. So I want to make sure that you guys have time to ask questions as well. One of the things about, I know looking through these notes, clearly some of them are older because it talks about how digital court reporting is, coming to a courtroom near you. It's pretty much all over Lancaster County and Douglas County. I've been struggling with Justice Hedican and court reporter stuff for 10 years. And I was 100% steno was the only way to go. It's the greatest thing ever. And I still think that is true. However, I can tell you again with Phyllis and her work ethic, she is equally as good as any steno that I've ever had. And digital recording is so much better than when it first came out. And she has the ability to do transcripts, and she will certify those. And so there's been a lot of miscommunication about if somebody has an electronic court reporter that you're going to have to hire somebody to do your trials. That's not true. They are just as sophisticated as a steno, and in some ways, actually, they have even more backup to the record. So it definitely is something, and unfortunately for our county court judges, we have stolen their staff to come up and become our court reporters, and so we apologize for that. But they're some really great people. So one of the things too that they kind of talked about as far as big advice, whether you're new or whether you've been around for a while, I can tell you there's some attorneys in some of these bigger law firms that don't get to court very often. And they come in and they act like, well, I've been in this town practicing law forever. You should know exactly who I am. I have never seen you before in my life. I have no idea who you are. My bailiff doesn't know who you are. So if you haven't been in a courtroom, regardless of how long you've been practicing law, introduce yourself. Introduce yourself, say who you are. I mean, it's all like that human connection, and you are going to get so much farther with my bailiff if you come in and say, hey, I'm so-and-so, I'm for blah, 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 and I'm here for this. How are you today? As opposed to, I'll give you this is one of my favorite stories. My bailiff was not at her desk. I had some criminal pretrials going on, and so I was sitting in her chair looking for a new date for a plea. And this very uptight, impatient attorney was kind of pacing around, and he comes in and looks at me and he goes, is the judge going to read everything that I submitted? And I go, yep, guaranteed. And he goes, well, is she going to be out anytime soon? I go, yep, why don't you go in there and have a seat in the courtroom? The judge will be right out. So I got the date for the criminal attorneys. I went and put my robe on and I walked out in the courtroom and I thought he was going to die. And it was the greatest, I loved it. So please introduce yourself to the bailiff so they know who you are, because that's really important. And again, the bailiff is your gateway to the courtroom. So if you are rude, if you are disrespectful, if you call and say, I just need a quick 15-minute hearing, and then you file 15 more motions in and do it electronically, and you don't tell the bailiff, she's going to be irritated, I'm going to be irritated, and we're not going to have enough time to do what we need to do. So, and that kind of goes back to what's a little bit different with district court. We don't necessarily know if you filed something electronically. In fact, we don't know if you filed something electronically. So if you file a motion to continue trial electronically and you haven't called my bailiff, we have no idea that it's even there. So you're not going to be heard, it's not going to be seen. So just make sure if you're filing something electronically and you need it to be seen or you need a hearing date, that you're also following it up. Even if you just send it in the email, it's going to get addressed. Let's see what else. I think that's it. One of the things as far as the life satisfaction and taking care of yourself, I've got a couple of rescue dogs, and so when I get home at the end of the day, when I've completely irritated attorneys, I have ruined litigants' lives with my decisions, the appellate court has told me how wrong I have been, I get home and those dogs don't care. They love me no matter what. So if you have a pet, that's fantastic. But also Theragun. It is the greatest investment, it's the greatest gadget you will ever have, because that little sucker is the only thing that gets rid of these rocks on the side of my neck when I've had a stressful day. So I highly recommend go get yourself there.
Any questions?
I have one for your pilot project.
Oh no, these were just questions for her.
Where does the text fit on that?
Same as before.
Same
Just,
as before.
yeah. It's more just trying to set the perspective right from the beginning. We want you moving your cases along. And it's nothing against the attorneys or anything, because I practiced it. So I know a lot of times it's not the attorneys that are dragging things out, it's their clients, because either they're angry with the other one, so they just don't want to do anything and they don't want things to progress, or they don't want to get divorced or whatever. I'm not like some other judges on the bench. I'm not talking people out of divorce. You want to get divorced, good luck for you. I'm not going to sit up there and, are you sure you want to get divorced? Is this something you really thought through? No, I don't care. If you want to get divorced, have at it. But it's more, and it's also more protection for the attorneys, because you're setting the expectation right from the beginning with your client. Here's the judge's order that says we have to do these things by this time. get on the ball, get me the stuff I need, let's get things going, and it forces parties to get together. Because I mean, I can't tell you how many times, and I've had it done as a private attorney too, where you get to court the day of trial and then you settle. That's such a waste of everyone's time. You don't get to talk, you gave me the microphone.
If I don't interrupt you, you're going to keep. One of the things that it kind of goes along with trying to move things along and having time. I've spoken at a lot of these where people say, well, I'm really irritated because when I call your bailiff, I can't get a temporary. And I realize temporaries are really important. We need to get those in as soon as possible. But a lot of that is because we have other members of the bar who don't let us know that they've settled something. They don't let us know that there's no longer a need for that hearing until either the day before or even the morning of, and so we can't put other things in there. I can tell you, even if you reach an agreement at 3 o'clock the day before, you're set for 9 o'clock, let us know, because I guarantee you there's a criminal defendant who wants a bond review and we can shove them in. So just make sure you let us know if you work things out. It's really important because I understand that there's a lot of attorneys that don't understand why we can't get things in, but I'm glad that now as a judge you realize why. And a lot of it is just because we have things that fall out at the last minute that, had we known earlier, we could have shut something in there and gotten it taken care of. So.
Any other questions?
Judges, would you prefer the electronic exhibits on thumb drive or email to?
So this is the discussion that we've had. Our AOC folks that changed the rules on us also said that you cannot put a thumb drive into a state computer because of the risk of viruses and things like that. So what my order that goes out, and then Phyllis will send a follow-up when it's time for you to have your exhibits in, and she'll tell you if she needs it. We need to email it to her. Each exhibit needs to be its own file. It needs to be paginated. And what Phyllis does is she takes all of those, she puts an electronic exhibit sticker on it, she does a full exhibit list, and she gets it back to both sides. So both sides know exactly what number, because a lot of times what happens, and I'm sure you've seen it before, where plaintiffs and defendants show up, you guys have marked your own stuff, and we've got 2 exhibit 2s, and we have 2 exhibit 3s, and so then we have to go through and say, well, no, don't mark your stuff, the court reporter will mark it. But this way, and I think once we get there where everyone's going to be doing it, it's going to be an email type situation where each court reporter is going to have their ability to be able to keep those. And one of the things I'll tell you, as far as like the electronics and the click share, when you hit that click share, it doesn't go up to everybody in the courtroom right away. So there's a monitor in front of the witness, and so you lay your foundation. If it hasn't been received into evidence yet, it's not going up on the big screen for everybody to see. So that's just kind of one of the concerns that some of the civil attorneys have had, and definitely the criminal attorneys, is what if it's an exhibit that you know that the foundation will not get laid and it's not coming in? Only the witness is going to see it until it's received into evidence and then shared.
That's the other point, is the rules don't say you can't have physical exhibits. So if you want to bring your own exhibits to the trial, you can, to show the witness those. But if you have them already also electronic, I'm not kidding, Mr. Weidbaum's trial was fantastic because they had stipulated to a lot of exhibits, but I mean, literally they would talk about an exhibit that comes in, boom, it's up on 2 giant 70-inch TVs in my courtroom. The jurors aren't wondering what it says. They're blowing it up. They're zooming in on what they want to talk about. First off, it's so much more interactive, and the jurors pay attention more. Because otherwise you get some jurors that sometimes get a little drowsy, get a little sleepy, and you got to take like a 5-minute break because you see 2 jurors that are just sound asleep in the back row because they're bored out of their mind. And that happens. There's jurors that have been asleep that I've had to stop in jury trial. Everybody stand up, take a stretch. Especially you in the back. The guy's been sitting there elbowing you for the last 5 minutes to wake up. So, yeah, he wasn't snoring yet, but he was about to fall out of his chair because he was doing the snap up. It's like, oh, wow. All right.
So, Your Honor, regardless if you can't be part of that trial, we have our stuff up there too.
Yep. It was, I'm not necessarily saying it was your trial that the guy was sleeping in but I think it might have been. It was the other side. It was the other side that was talking.
So there was an interesting question at the end of that one here I never heard. At the end, I asked the panel, do you have any questions for me? And one man in the front row said, why do we have to be here? Why can't we be online? So,
Yes. Because that was, he did. One of the prospective jurors said, why do we have to be here? And it's like, it took me, I was like, are you serious? You think you're going to get a set in your home, in your living room, and serve as a juror in a jury trial? But he did. He literally, he's like, I have not been, didn't he say, I have not been out of my home in the last, year and a half. I've not been to work. I have not gone in. I've worked remotely. Why can't we do this remotely? And it's like, no. Because you're a juror, and that's not how it works.
We have to consider that. I mean, we have witnesses that showed up in New York and other places that perfectly work great on Zoom.
And I think
What would be wrong with that?
I think what I said was also when you've got witnesses that are showing up remotely, we have some control over that. That the attorneys or officers of the court, they're assuring that that person is where they're supposed to be. They're being sworn in. Jurors, I have no idea where they're at. I have no idea if they're sitting at home, if they're sitting watching TV, or what they're doing. We have no means to control them remotely like we do witnesses. So, but I've never had a criminal jury trial or a criminal trial, period, remotely. I couldn't imagine.
Judge Bazis, is that what they're doing in Lincoln? Is that what what you're doing?
No, not trials. We're not doing any trials, but the federal courts in some other jurisdictions have done civil jury trials. There has been big satisfaction with that, but there is with the judges. Yes, everybody. And so if you had technical issues, they sent out either laptops or iPads so they could connect. But there was a order in place of what the expectation was, meaning you're not going to be in your pajamas in your bed, but you have to find a quiet area to do that. And kind of what the feedback was, which was kind of interesting, was that the jurors actually felt that they were more engaged because they could see the witnesses, because you have the face right there and the facial expressions, and they're actually closer to the jurors, and then the evidence is being put up on iPad or computer so they can see the evidence better than you would in a courtroom. Now, the judges seem to think that it went well and liked it, and I think some have continued to do that in other jurisdictions. Do I think that will happen here? No, I don't, to be honest. But it went better than I actually thought it would. What I do think, which will continue, at least in the federal courts, is witnesses are allowed to appear remotely. Now, some courtrooms have better technology than others, and so it has been a struggle in some of the courtrooms. But before the pandemic, that would not happen unless you had a really compelling reason. It just wasn't happening. So that is happening more. The judges are open to doing that. But doing a full trial that way in Nebraska, I don't think so. But it is happening around the country, and it's been successful. Now, whether it will ultimately, at the end of the day, continue remains to be seen. But I can say some of them who are really, really behind have been able to get a lot of trials done this way for scheduling purposes.
One last question, if anybody has it.
Somebody had their hand up back there.
I did, but I'm going to ask you.
Oh! Can we give a round of applause for our judge? Thank you all for coming. Thanks for being here on a Friday afternoon. Tell everybody else about this so they can watch it online. Thanks.